Hello everyone, welcome back to Live Law Academy. Hello everyone, welcome back to Live Law Academy. I hope all of you are doing great and wonderful. So do you remember the Babita Punia judgment from 2010? Or the Lieutenant Colonel Nitisha and others versus Union of India from 2021? If yes, then you know what am I speaking about or what is going to be our discussion for today's session. Yes, rights of women to join Indian Armed Forces. This case by the Honorable Supreme Court has been decided related to a specific entry in the armed forces, that is the JAG entry, Judge Advocate General entry. Okay, so why the notification was challenged? Let me introduce you to the facts. Okay, if you see the last 10 years, okay, pick last 10 years of notification for this entry, you will see a pattern that has been there. For the male candidate, if let's say hypothetically the seats notified are 7 or 8, for the women candidate it would be around 3 to 4. So the pattern has been of this sort that around half of the seats are notified for the women candidate for JAG entry. And this is exactly one of the grounds for which the notification was challenged. That why the number of seats are lesser for women candidate first. Second, as we understand that the procedure for both the male as well as the female candidates is same. It's not even similar, it's same. Okay, so the SSB procedure, the medical procedure is the same that both the candidates have to go through. Then why are we differentiating in the merit? The second ground of challenge is on the basis of merit, that hypothetically you can refer to the judgment to see that what was the score received by the petitioner as well as the male counterparts. But I will hypothetically give you an example that, for example, if there were 3 seats notified for women candidate, the fourth woman here has achieved or has secured 450 marks. Okay, versus there were 7 seats for male candidates, and the seventh male candidate who's going to join has secured around 425 marks. So 450 versus 425. He gets to join the armed forces. She does not get to join the armed forces because of the change or because of the difference in the merit. So the second point of contention or challenging this was on the basis of merit. That why do we differentiate in merit? And if we do so, are we really in essence promoting gender equality, or are we promoting gender neutrality? And what is the difference between the two? Okay, so we are going to discuss this aspect as well. And in addition to this, all of these have been done. The Supreme Court has here answered these questions on the basis of various aspects. Okay, so they have spoken about how now in the present times, when we talk about Article 14, 15, 16, 19, these string of fundamental rights, okay, 14, 15, 16, 19, read with Article 33 of the Indian Constitution, when we read them together, we understand and acknowledge that yes, the fundamental rights that are available are restrictively available or cannot be claimed as a matter of right. But at the same time, to keeping in mind Article 33 or the idea of Article 33, we have a provision under the Army Act of 1950. So Section 12 of the Army Act of 1950 specifically mentions, and in 1950 they had codified that women will not be allowed to join the armed forces unless and until it is so notified by the government in the official gazette. And of course, we have notified the same, and there are certain cadres by which we say that these around 10 cadres are there by which the women can join the armed forces, JAG being one of those. This is the language of Section 12 of Army Act. Okay, so there is no limitation as to the extent of how or how many of the women would be joining. There's no restriction, there's no embargo that has been imposed by Section 12 of the Army Act. And if that is not so, how in this in these notifications, we are seeing that discrepancy, or we are seeing this embargo being imposed. That also has been a discussion that has been done over here. So these are certain questions that I have presented to you, which have been discussed in the judgment. I will take you to the judgment. I'll show you certain paragraphs and certain relevant aspects of the judgment for you to get it better. Okay. Now, before I go further and before I go to the judgment, let me just tell you as to how the fundamental rights have been discussed here. Okay. I'll keep it crisp so that you get a good understanding of what has really happened. There are two ways of you to understand this better. One is that you can go to the LiveLaw app and you will see an article already published on the LiveLaw app providing summary of the judgment. Okay, so the judgment was delivered on 11th of August, and accordingly on the same day we have already put an article or related to the judgment. Or you can then go to the article and at the end you will find the original copy of the judgment. You can refer to the judgment as well, which I'll be showing you at least today. Okay. Now the judgment here has done certain juristic and done certain theoretical discussion on the concept of equality. So I'll first be talking about that as to how do we really see, or what are the different approaches for us to understand the question of gender difference and gender equality. The judgment here has referred to one aspect of the three lenses by which we see this. One is protectionist, one is sameness, and the third one is compensatory. We talk about protectionist, wherein we try to give certain extra protection to women, keeping in mind that there is gender difference and we have to promote equality, right? Second is sameness, wherein we do not give extra protection, rather equality is to be promoted, is similar and same protection is to be given to both the genders. And the third one being compensatory, we acknowledge the fact that how this gender has faced a lot of discrimination, has been deprived of a lot of benefits that could have been availed by them, and accordingly frame our policies. These are approaches by which we have to see women, right? But the judgment does not stop here. It does not stop to these theoretical aspects, and it rather goes ahead with understanding of that how the restriction on the extent of induction, that is three seats for women versus 8 seats for male candidates or 7 seats for male candidates, where is this restriction coming from on the extent of induction? Is that mentioned in section 12 of the Army Act? If that is not so mentioned, then can we say that this is violative of the all these principles, all these fundamental rights, basic fundamental rights given by the Indian Constitution? Then, in addition to that, it also has spoken about various aspects related to how do we really see women in the armed forces. So, there have been discussions by the respondent. A lot of arguments were made as to how, for example, the posting given are different, or the threshold of efficiency, the threshold of how, the input that is to be put is different. The court has here answered and referred to various aspects. One such aspect is, for example, the field parity, which has already been institutionalized. So before, definitely, yes, it was so that when we talk about JAG entry, there used to be, infantry posting for the male candidates for a specific period of time, which was not so there for the women candidate. But this has been taken away. This has been taken away, and accordingly now there is parity with regards to the field parity, right? As we say, which is available when we talk about posting, when we talk about training, when we talk about all the hazards that are there. All of these are all both the genders are exposed to it in an equal manner, and that is how we have to see that such notification, keeping in mind these aspects, does appear to be unconstitutional, because how can it double the number of vacancy for males? Isn't it primarily unconstitutional in nature? Secondly, it very clearly mentions and qualifies that we are not promoting gender neutrality. Rather, we are still stuck with gender equality. Now, let's understand what is the meaning of, or what is the difference between the two. When we talk about gender equality, we are basically saying that the employer will hire the same number of men and women. Okay, this is gender equality. But when we talk about gender neutrality, we are basically referring that the best of candidate, irrespective the horse of which gender do you really fall in, the best of candidates will be picked in the merit. And this is the reason why in this judgment the Supreme Court has said that we would request now you to prepare one uniform merit depending on who qualifies, whether it is male candidate or female candidate, based on their expertise, based on their qualification, the skills that they possess, you let them join. Does not matter whether 10 women are joining or 10 men are joining, it will not bring any difference because we are promoting gender neutrality. Okay, so this also has been a very wonderful discussion, which is the basis of the judgment as to how the judgment here has laid down guidelines for future recruitment to be done. Now let me take you to the copy of the case. So this is the judgment, the copy of the judgment. You just have to see the index. If you see the index, you will realize that how we have spoken about various aspects which I've just discussed with you. Field parity to be institutionalized, and then argument that the women officers are not posted where contact enemies is it has no basis. Okay, these are all of these have been addressed by the Honorable Supreme Court, and they have said that all of this is no basis, especially when we are talking about this branch, which is JAG branch, right? Then the court has also referred to the policy of enrollment has to be gender neutral and not gender specific. And likewise, as I was saying, we also have made a discussion on gender equal and gender neutral. Then the court here says that when the test is same, the nature of test is same for both the candidates, why not prepare a combined merit list that ought to be prepared, and accordingly we have to promote the joining of from both the genders to be done in an equal manner, right? Constitutional interpretation has been done, and the merit selection, all of this has been now approved by the Honorable Supreme Court to be done, keeping in mind a gender neutral policy. Okay, so the judgment starts with the procedure. They do a thorough discussion on what are the OLQs and what is the procedure for allowing the candidates to qualify. And to go for the medical and accordingly join the army. Then they have also spoken about the different string of constitutional rights. As I was already telling you, a lengthy discussion has been done on the basis of all of these constitutional rights as well. Now, the court has already mentioned that very, very nicely that we already have codified or we have institutionalized field parity between both the genders, and accordingly it should be followed. There are certain very beautiful points in the judgment, okay, that I've come across. I'll just take you through those. First one being here that the court has realized that people fear change, and this judgment is definitely going to bring fear. But remember, people feared electricity when it was first invented. But do we fear that now? No, it is rather more beneficial for our own use, right? These are the three type of approaches which the judgment refers to that I've already spoken about. And then the judgment takes us through various facts, right? A fact check has been done with regards to how women are doing great and well in the judicial services, how we do not allow them significantly similar opportunities, and therefore they've not been able to contribute to the GDP in the same manner as the other gender. And keeping all of these things in mind, therefore, it is very important that the respondents have to establish a gender neutral selection process. So this is what the judgment is all about, and I hope you've understood the judgment. I hope you will be able to write a decent answer on the basis of this, and I hope you will be able to read the judgment now in context of the different aspects that I've discussed just now with you. right? Okay. So thank you, all of you. I hope this was a beneficial discussion. I'll see you again with another landmark update or recent update. Thank you and have a great day.